Parenting.com reports Maine, Michigan, and Utah are among the few states where courts are required to consider breastfeeding when making custody and visitation decisions. In every divorce action, we know there are two sides to every situation, even when it comes to nursing a baby. The Nursing Baby and Nurturing Families website reports the American Academy of Pediatrics and the World Health Organization recommend babies be breastfed for at least 1 year, preferably until age 2 or beyond. They also cite breastfeeding is no longer considered a lifestyle choice, but a long-term healthy choice. Breastfeeding and divorce became a hot topic when a Virginia couple found themselves in court because mom insisted on breastfeeding she and her ex-husband's baby daughter, and the dad said it was interfering with his parenting time. Well, here to talk about breastfeeding, divorce, and custody is our friend, Anna Krolikowska. Anna is the founder of the Illinois firm Anna K. Law. Anna is also a trained litigator, mediator. She's also a certified collaborative divorce professional. Her goal is to keep clients out of court. Back in 2021, Anna was appointed and elected the 145th president of the Illinois State Bar Association. And most recently, she was elected Best Lawyers in America 2023, which I'm not surprised. Anna, welcome.
Thank you for having me, Ilyssa.
Well, congratulations, and thank you for being here. So are there laws or provisions in the state of Illinois when it comes to breastfeeding, divorce, and determining custody?
There's nothing specifically that points to breastfeeding in Illinois, but when a judge is looking at questions of custody and parenting time, he or she is going to look at a series of factors as far as what should happen in relation to the decision-making and the parenting time. And their starting point is going to be what's in the best interest of the child. And flowing from that is a belief that unless there's something wrong happening, unless there's harm being caused, both parents should be involved in the life of the child. So to the extent a mom is breastfeeding, it would be one of the factors or components a judge would take into account when deciding what sort of a parenting schedule there should be.
Describe how breastfeeding can impact a custody agreement in a divorce action when mom wants to nurse and maybe dad is not fully on board because, again, he feels it's interfering with his parenting time.
Right. And so in this situation, they're not agreeing. They're not trying to figure out a settlement where maybe some of their respective needs are being met, but neither one of them gets exactly fully 100% what they want. So a judge would be looking at figuring out a schedule that supports the child having contact with both parents. That might mean, especially with younger children, more frequent contact with both parents rather than extended periods of time. So maybe it's 3 hours every day rather than having the child spend 4 days with one parent or the other. It might mean the judge saying, mom needs to make sure that the child is available and prepared and ready to go, and to the extent it's feasible, pumping breast milk so that it's available and dad can give the child breast milk, or mom can give the child breast milk via bottle. Or it might also mean that the child's feeding schedule is supplemented with formula. Again, there are a lot of different options. And the one constant is that if you're in court, if you're fighting over this, ultimately that judge is going to make that decision unless you settle. So you are giving up the control over what happens to your child and your family to that judge.
And I like that you just used the word control because your practice focuses a lot on mediation and collaboration, which allows people to stay in control of their case. So how can two parties who are on different sides come to a meeting of the mind so they don't lose control and both can find a solution that works best for them?
There's a lot of communication. We talk about what's important to each of them. What are their priorities? And if the priorities are to both support a good relationship between the child and each of his or her parents, as well as support the breastfeeding, then how can we structure an agreement or a parenting schedule that works? And keep in mind, this particular schedule might only be in place for a year or two. You can always modify it to a different schedule when the child or as the child grows older. But in this particular instance, let's say we're talking about a small child. Again, maybe it's more frequent but shorter periods of time with parents, 3 hours, 6 hours, whatever it might be. Again, it will require a lot of flexibility and commitment from both parents. It might be that, for example, sometimes people will choose to nest, and that means that the child stays in the home and the parents rotate in and out. That's another option that can be used. It might mean, again, mom making sure that there's breast milk available that can be given to the child via bottle, or it might mean supplementing with formula. There isn't going to be a 100 perfect solution that will satisfy everyone's wants and needs, but that's why you're settling, right? You're not rolling the dice and taking the risk that you will lose on everything that you're asking for, and you're minimizing your downside by arriving at an agreement that you can at least live with.
In Illinois, if the mediation and collaborative process fails, as you just made reference to, parents are going to have to go before a judge. If the matter goes to court, will the judge likely appoint a guardian ad litem and ask other experts, maybe such as the family pediatrician, to come in, weigh in on the situation, and then testify?
What a great question. So if you cannot agree, yes, the matter will go to court. And at that point, the judge can either appoint a guardian ad litem on his or her own, or you can request it as one of the litigants. If that happens, that guardian ad litem is the ears and eyes of the court. So generally, these are professionals, attorneys who have been practicing in this area for quite some time, and they will investigate. They will talk to the parents. They will ask to see the child interact with each parent at his or her home. They will ask for information about collateral contacts like pediatricians, like extended family members, and communicate with those folks. And then they can incorporate all of that information into a report they give to the court and a recommendation. They can recommend to the judge what sort of custody arrangement, what sort of a parenting schedule should be put in place. Now, you might have parents who don't agree with the guardian's recommendation. And if that's the case, then they have to bring in their own experts, their own witnesses, for example, the child's pediatrician and other experts to testify on their behalf. Ultimately, at the end of that process, that lengthy and often expensive process, the judge, as the trier of fact, has to weigh in all that information and make a decision.
You know, in the Virginia case I made reference to in the open, the ex-husband's attorney was reportedly accusing the former wife of trying to use breastfeeding as a weapon. Why would a lawyer cite an allegation like this?
I can't really speak to the specifics of this case or what the trial strategy is here, but it sounds like this attorney was a zealous advocate for the dad in this instance. And maybe he or she is privy to facts and details that we are not quite aware of. I assume that mom's attorney made a zealous argument on her behalf as well. However, that statement is fairly inflammatory.
You know, in Illinois, we were just talking about all the expert testimony that people such as maybe a guardian ad litem, maybe a lactation specialist, the kid's pediatrician, will be submitting to the court. After the judge reads everything, can he make a ruling for mom to limit her breastfeeding time and encourage the baby to take the bottle? Again, because dad is complaining that nursing is interfering with his allocated time.
He can. Ultimately, if you cannot agree, if you cannot settle, and your state's law doesn't protect breastfeeding, then yes, the judge is going to look at totality of all the facts, of all the evidence that was submitted to him or her, and make a decision as to what should happen. And that is an unfortunate circumstance. However, there is no other way that I, as an attorney, am aware of if folks cannot settle their dispute. There is no other recourse.
You know, one thing we
meaning
talked about,
a judge deciding.
Yeah, and one thing that you had talked about once when we were talking about all the different types of custody is that in Illinois where you practice, courts really like to try to leave it 50-50 so children have equal time with each parent. Is that still the case when kids are so young like this, when a baby may be attached to the mom's breast?
Not necessarily. So the idea is involvement of both parents, and the courts try to facilitate that as best as possible. But there might be periods of time where it's an unrealistic expectation, whether that is a situation where the child is really young, or maybe one parent travels frequently from work. I know these are not exactly the same examples, but there might be instances where maybe that parenting isn't always 50-50, but it can change as the children grow older. There is a difference, however, on making changes or modifying that parenting time by agreement versus going to court to litigate that issue. And I think we've talked about that at some time in the past.
Yeah. And last question, because I know we're running out of time. Custody could always be modified, correct?
Yes, it can. Absolutely. Whether that's by agreement or by going back to court and asking the judge to modify it. But if you're going to court, you have to convince the judge that there's a valid reason as to why it should be changed.
Well, one thing I know we do need is your contact information. Anna, how do people get in touch with you?
You are welcome to check out my website at www.annaklaw.com. That's annaklaw.com, or call my office at 847-715-9328, 847-715-9328.
Anna, thanks so much for joining us. Don't go anywhere. We will be right back after this break.
Anna Krolikowska is the principal of Anna K. Law. Based in Illinois and serving clients all around the state, Anna and her practice offer divorce services, mediation services, collaborative divorce, prenuptial agreements, and legal counsel to clients considering marital dissolution. Anna is also the president of the Illinois State Bar Association and holds leadership and membership roles in more than a dozen professional organizations in Illinois and nationally. Anna has been awarded Chicago Daily Law Bulletin's 40 Under 40 to Watch and included in the Salute to Top 50 Women in Law. She's also been named a super lawyer and a leading lawyer, distinctions that are offered to less than 2% of the practicing attorneys in Illinois and are based on selection by her peers. More than anything, Anna is devoting her career to couples and families, and as a trained collaborative attorney, she focuses on guiding people through some of the most challenging life experiences with dignity and respect. Contact Anna at annaklaw.com. That's annaklaw.com. That's ANNAKLAW.com.